Well, hi, this is Ken Auerbach from Cartier, Bernstein, Auerbach, and Steinberg. If you or someone you care for has been injured from no fault of their own, please contact Cartier, Bernstein, Auerbach, and Steinberg at myinjuryli.com or call 631-654-4900. Whether auto or work-related, slip and fall, trip and fall, construction accidents, dog bite, medical malpractice, or nursing home neglect, or various other types of negligence, please contact me at Cartier, Bernstein, Auerbach, and Steinberg by visiting me at myinjuryli.com or call 631-654-4900. I will represent you with integrity and passion. Living in pain from no fault of your own can be emotionally and physically detrimental and affect all aspects of your life. Please contact me, Ken Auerbach, at Cartier, Bernstein, Auerbach, and Steinberg by visiting myinjuryli.com or call 631-654-4900 for an immediate and free consultation and the support and representation you deserve. Well, hi, everyone. This is personal injury attorney Ken Auerbach from Cartier, Bernstein, Auerbach, and Steinberg. Welcome back to our program, From No Fault of Your Own. We're here live with my great associate and co-host, Amanda Spindler. Amanda, welcome.
Thank you. Happy to be here.
Yeah, it seems like the weather's warming up a little bit.
It is. It's supposed to be nice this week.
So I think maybe you brought some back from Florida when you went to Orlando.
I brought some of that heat.
I think from Disney. Amanda, you always bring the heat, man. You always bring the heat. Fighting these insurance companies. They know when you're on the other side.
They don't mess with me.
They shouldn't. Well, folks, as you know, it's our goal to give you an insider's view of bringing and proceeding with personal injury matters and those matters which are caused by the negligence of some other party. And among these areas, we will explore and will continue to explore and have explored are car accidents, trip and falls, slip and falls, construction accidents, medical malpractice, nursing home neglect, products liability, and the serious injuries that do oftentimes occur. And through our journey together, hopefully we've removed some mystery and uncertainty and helped you feel empowered, knowledgeable, and confident in the process. It's been great. You guys have been calling us up after the program oftentimes and asking for help, and we've gone over a bunch of different scenarios and been able to help you get justice, and that's really what it's all about. We are live today, so if you have any questions, give us a call. Don't be shy. We're in the studio right now. You can call us at 631-451-1039. Amanda, if they call in, what can we do for them?
You will get a free From No Fault of Your Own t-shirt.
Well, that sounds good. I think what we're going to do too, Amanda, it's baseball season coming up, right?
Yes.
So I think what we're going to do, Amanda, in one of our next couple of shows, we're going to have to give out some baseball tickets.
Wow.
What do you think?
High stakes. Yeah, I love it.
I think it's really good too. So far out, the Yankees got off to a good start. The Mets, pretty good. And hopefully we have some great baseball this spring. And as it warms up, we'll really be able to enjoy it. So let's get back to why we're here. We're here to talk about personal injury. And one of the areas that we've spoken about before, Amanda, and I thought it would be a good idea because we get many calls on it, are construction accident cases.
Right.
So, Amanda, could you tell our listeners, when we talk about a construction accident, what are we talking about? Just give a flavor of the type of cases.
So a lot of times it's someone working on a construction site, whether that be at a residential home where, there's remodeling or new construction. And oftentimes it's a fall from a height.
So what we do on these cases, folks, is we really have to take time up front and listen to you and listen to really what happens. So we've had all different types of cases. Now, there are cases that we have sometimes that you would not necessarily characterize it as what we call a labor law case,
right,
or a height-related claim. But when we listen to the details of it, the law might say that is designated as a labor law case or height-related claim, and it makes a difference. So if we have a height-related case where someone falls from a height and it's not a 1-2 family home, there are specific requirements that require there to be certain things done, but that actually will hold the owner of the property and general contractor strictly liable, actually, for any injuries that occur, irrespective of whether there is actually negligence. Now, we can't really go into all the details of it on the show, but think of it this way. If you're on a commercial site, let's say you go to work, and you're working for, let's say, a contractor that's doing some type of construction. They might be doing carpentry. They might be doing a renovation in terms of It could be electrical. It could be tin knockers. It could be steel workers. It could be iron workers. So all of those scenarios oftentimes will expose you to certain types of risks on construction sites. And we've handled all different types of those cases. And a lot of times we'll get a call from somebody. They'll call us up. They'll think, well, maybe they're just limited to workers' compensation, right? And Amanda,
Right.
the difference with workers' compensation versus a third-party case is what?
So in the third party case, you're not going against your employer. Obviously, you're not able to. So we're going against, like you said, the general contractor, the homeowner. Typically, that's who you would be third partying.
So there'd be an owner of a property or a general contractor on a commercial site. On a residential site, you possibly also can have, oftentimes you have a general contractor.
Right.
The homeowner is actually, there's an exception to it. Depends if it's a 1 or 2 family home and you didn't directly supervise it. So those are just different scenarios. But in general, what we're looking at is we're looking at people who go to work on a construction site. And the definition of that is based upon literally certain facts. And we have to look at that. We have to evaluate it. As an example, if somebody goes to a construction site and they're just doing regular painting, regular maintenance painting, that's not considered actually a construction in itself. Okay, just general painting, general maintenance.
Right. Under the labor law, it wouldn't be considered that type of case.
Under the labor law.
Right.
For purposes of strict liability. However, we've had cases where a person has gone on a site and let's say they're a painter. But actually what they were doing was they weren't actually painting. They were renovating an area and they were going ahead and expanding an area that was a billboard. Now, the billboard that was in place before was the same billboard, but they were extending it and they were renovating it. In that case, that actually, under the law, constituted a construction zone. And we were able to get a very significant recovery for that person and actually several others. So each case, what we like to tell you, and that's what Amanda and I on the show have told you, is it's important that you give us the call.
Very, very fact specific to each case, especially under this category.
And so when you call us, you might think, well, I can't sue my employer because I'm limited workers' comp. And now you're not concentrated on that. Well, however, we listen to it and we think and we see, is there a third party? Now, the advantage of bringing a third party case is that you can make a recovery for conscious pain and suffering, for both past and future pain and suffering, that you're unable to do so in a workers' compensation matter.
And oftentimes in these cases, there's pretty catastrophic injuries.
That's right. And the pain can be extensive. And so workers' comp is going to reimburse you for, and the way they categorize it is for essentially economic loss.
Right.
Okay. For your lost time. And they will actually come up with certain percentages in terms of limitation. But the problem is it doesn't really reimburse you for that pain. And
Right.
It doesn't. So the idea here is to get you fully compensated. And even though workers' comp might have a lien, well, they'll have a lien to get reimbursed, what your recovery could be under third parties oftentimes significantly greater than what you would otherwise get under workers' comp. So it's important for us to look at it, take the time, give us a call, let us spend time with you to evaluate it and let you know, do we think you have a case? You may not see it. Literally not see it. And I can't tell you how many times that's occurred, Amanda, right? Where we get calls like that.
Yeah, I think every week pretty much we get a call, someone saying, I think it's just workers' compensation. But we do oftentimes see that third party element. So,
and we're also interested too, is if you come to us and call us up and happens to be a workers' comp claim, it's not a problem. We work with workers' comp attorneys. We have had some on the show here. Bill Turley, absolutely fine
Yes.
workers' comp attorney. Where we'll make sure that you get to a really good workers' comp attorney that's going to fight for you. And oftentimes, we're working the cases together. The compensation attorney's working on the comp end. We're working on the third-party end. So when you get to us, and you get to us early, before someone's going to go ahead, try to get to you and try to really kind of speak to you and sort of slant facts. I'm a little cynical because I've been doing this for a long time. And unfortunately, many times the insurance companies for these defendants, they're not looking for justice for you. They're just not. They're looking to limit their liability. We're looking for what's fair and just. That's what we're looking for. So get to us. Give us a chance to go ahead and talk to you early on in the process so that we can give you your best shot to get justice. That's what it's all about. It's about you getting justice. So on the other side of the show, we're going to bring back on the show the great David Levenstein.
Always my favorite guest.
He is a great guest because David actually asks the most prompting questions. And so we're going to bring David on, and we're going to let David go ahead and do as he oftentimes does, open up our thought processes for things we might not have thought of. So we will see you on the other side. Well, welcome back to our program. If you're just joining us, this is personal injury attorney Ken Auerbach. You're on our program from No Fault of Your Own. We are live today, and we're exploring some of the most important issues in personal injuries caused by accidents. If you or someone you care about has been injured as a direct result of someone else's negligence, give us a call at 631-654-4900. You can get us on the web, too, at myinjuryli.com. Give us a call at 631-654-4900 or on the web, myinjuryli.com. It really would be our privilege to fight for you, to get you justice, to answer your questions. And all of our consultations on personal injury cases are always free. It doesn't cost you anything unless we make a recovery. So if you do retain us, you also don't pay us unless we make a recovery. We'll lay out expenses for you and do that. And we are here every Monday, Amanda, from what time?
From 4 to 5 p.m.
as we explore these issues. And if you want to listen to some of our older shows or other shows, we have shows with all different types of medical doctors, doctors that deal in the neuropsychological field, doctors that deal in the neurologic fields, surgical fields. We've had many of our clients on the show too. Mm-hmm. We've had experts of all different areas. Listen to our shows. We have them right on our website. Amanda, how do they get to them?
So if you visit our website, we have a little radio show tab, and you can pull down that tab and listen to a whole plethora of shows.
We have a few new listeners out there. I'd like to give a shout out to them, out to Dean and Patrina. Hello. We're really glad that you're listening, and hopefully we've added a little bit to your day. And also Arthur's out there listening too. So we really do appreciate you folks out there. We appreciate knowing that you are listening. And we know that it's our privilege to try to help you. It's our privilege to try to give you information so that your journey through this area is a little bit easier and hopefully successful. So we're back here with the great David Levenstein. David, we'd love to have you on the show.
I love being on the show.
You are like the gold standard in question asking.
Well, I like to listen to your show, as I do others, from our listeners, our audience's point of view. And it's important that they get their question answered. A lot of people are a little gun shy when it comes to calling into radio shows, especially because it's such an open-ended conversation to have when you're speaking to an attorney. It's not, a heated political conversation where they can just do a hit-and-run comment. So there's a lot to talk about. So I'm going to, if you don't mind, just mention a couple of things that you talked about, okay?
Sure.
And I'm thinking about this because of the work that we want to do at our house. And we have gutters that need to be changed and all of that things. And I said to my wife, I said, if someone comes to clean the gutters, a handyman, right? Mm-hmm. He asked if we can use the ladder that we have in the garage.
Right.
And I told my wife, I don't care if it's a brand new ladder, don't you dare give him that ladder. Because if he falls through it, if he missteps, I don't know. Let him bring his own ladder. If he doesn't have it, then he can't do the job. I'm nervous about hiring him anyway.
Well, I mean, in general, I think that's really a good standard to have anyhow, because if anybody's going to be working on your house and isn't able to bring a basic tool of a ladder,
right.
Probably not a good idea to have them working on your house.
Right. But he did ask, can I use that ladder that was in the garage? And I was like, no.
It's broken.
And I don't know if that's, if I give him a ladder to use on a job that he himself wants to use, and he's asking me to use a ladder, am I responsible if he falls off that ladder?
It's possible that you could be.
Right.
Yeah.
So that ladder now is a ladder, of course, that you own.
Right.
And if that ladder is defective in some way,
mm-hmm.
and you were aware of it beforehand.
Right.
So let's say that you knew that ladder was the type of ladder that didn't stand straight or was wobbly.
Okay.
And you were aware of that. particularly if you're aware that someone got hurt, fell off that ladder before, you've now opened yourself up for possible exposure.
Right.
Whereas if, of course, if you didn't use that ladder, you wouldn't have that issue. The other issue with a ladder is that, and I have had cases dealing with ladders at people's homes, is even if you have the possibility of having a manufacturer in the equation, the thing is that it may not be a manufacturing defect. It may be a defect that occurred, after the ladder was purchased. Maybe it wasn't used properly.
Right.
Maybe
or stored properly or anything.
Or stored properly or not. You're right. So there's a lot of different things that could happen with that. I just kind of have that sense. Amanda, I think you'd agree.
Yes, I agree. I think you're better off in your scenario having them bring their own ladder.
So, that being said, didn't go with this person, so we are hiring a company that does clean gutters, and, they are licensed, they are insured, but is it my responsibility, if they're working on the outside of the house, where the grounds are uneven, things like that, to provide them with a safe work environment? Is that, if they fall, is that my responsibility?
So that's an interesting question. So we were talking about earlier on the show, when we were talking about the idea of certain types of construction accidents and what we call strict liability. Is it a construction site? So in general, I can answer that you would not be responsible in general for what you just talked about because it is a 1 or 2 family home, and there's an exception to that under the labor law. However, that does not mean that you still couldn't get sued for negligence. And so common law negligence simply means is like you'd sue anybody else, saying, hey, you didn't act reasonably under the circumstances, okay? So let's say that it's a 1 or 2 family home, and you're not, in fact, in that case, supervising the job. Now, if you were supervising the job and really taking control of it, you could have liability under the labor law. You could have liability. But let's say you were not. But let's say that there was something about the premises that you were aware that you had created that was unsafe. So what if you had an area where you had put a board over it? It was a hole, and you put the board over that hole. And it was sort of covered up, but not covered up well enough. If you created that condition, you as the homeowner, you could absolutely be liable for negligence. And so when you bring somebody onto your premises, even though it may not be that you're involved in the construction process, you still have to protect them from what a reasonable person would expect from happening.
So let's say you have a general contractor, and the general contractor hires all the workers in the house. Am I still responsible for what you just described? Or is the general contractor now responsible? He should inspect the property before he starts hiring his guys to fix up the home.
So, Amanda, why don't you go with that?
So I think, again, it's the same scenario. It could be you both could be responsible because under the labor law, both the general contractor and the owner of the premises can be held strictly liable. Obviously, it depends, again, on the circumstances. Like Ken said, are you there overseeing all of the work? Are you really...
But that's why you hire a general contractor, so you don't have to oversee everything.
But the thing is there's a factual question. So you may not have to do it. You may not be required to oversee it. But what if you're one of those people who can't help themselves? So when people come onto your property, you're the person that's always pointing the finger and saying, go here, go there, do this, do that. And even though you were not required to do that, you did it. Now you've now taken a situation under the labor law where you may not have been liable before under the labor law. And now you are. However, let me tell you this. If you have a defect on your property, okay, you have a big hole in the lawn. You've had that hole. You tell the contractors, okay, just come across this way. You know you've had that hole in the lawn, okay, for the last 5 years. And, your wife's been telling you to fill that hole in. Someone is going to get hurt. And you just say, yeah. Nobody ever walks over there. But you forgot this time. You told them this is the best way to go. Now somebody goes in there, falls in that hole, and hurts themselves.
Let's say they pointed out to the general contractor beforehand that there's a hole in the... and the general contractors, I guess you could be liable as well, right?
Well, you'd have to look at the scenario. Well, you pointed it out to the general contractor. Okay, well, what was the general contractor going to do about it? Did you then have a conversation with the general contractor said, all right, well, I'm going to keep everybody away from that, or I'm going to put barriers around that, or I'm going to do something.
Right.
But as between, if you think about it, yourself and that third party.
Yeah.
Okay, that third party who wasn't the general contractor, didn't have that conversation with you. Should you now not have responsibility with a defect, a known defect that's on your property that you didn't do something about?
So when we come back, I do have a lot of questions that are popping up through my face into my face, out of my mouth. Is because from the other side is that if somebody does get, if I'm hired by a general contractor to do some work in someone's house and I do get hurt, what direction do I take my lawsuit?
Well, it's a good question. And when we get back, David, we have plenty of time for all your questions. So it's great to have David Levenstein on the program, and he's of the people. Ask the questions of the people. We'll see you on the other side. Well, hi, everybody. If you're just joining us, this is personal injury attorney Ken Auerbach. You're on our program from no fault of your own. I'm here with my great associate, Amanda Spinner, and my co-host. And we are exploring some of the most important issues in personal injuries caused by accidents. We are live, so if you want to give us a call, you have any questions, we'd love to answer them. We have David Levenstein, of course, asking the questions of the people, because he hears all those questions, so he's asking them. But love to hear your voices, too. And if you want to call in, it's 631-451-1039. And if you or someone you care about has been injured as a direct result of someone else's negligence, give us a call at 631-654-4900, or get us on the web at myinjuryli.com. That's 631-654-4900, or get us on the web at myinjuryli.com. It really would be our privilege to fight to get you justice. And if you want to sit with us, all of our consultations on personal injury cases are free. If you happen to go ahead and retain us, then you don't pay a dime unless we make a recovery. We'll also lay out expenses. You don't have to pay us those back either unless we make a recovery. And listen to our program every Monday. Amanda, what time?
From 4 to 5 p.m.
And so love you to listen to that and get on and really ask us your questions. So it really is a privilege. So, David, we're back here. David, you were prompting us with some really good questions at the first half. And so why don't we continue on?
Okay, so if I'm working for a general contractor, or if I'm a handyman and I'm working and I do get injured on the job at your home, who do I sue? Do I sue the general contractor that hired me?
Good question.
Because the general contractor, I would imagine, is supposed to provide me with a safe environment in which to work. Or do I sue the homeowner, or am I just suing everybody?
So I guess let's start out with, in your scenario, are you saying that that person was an employee of the general contractor or a subcontractor?
The person's Oh, that's a good question. Well, let's look at both. Let's say a general contractor will sub out different work for plumbing, for roofing, for windows, things like that, right?
Yeah. So, Amanda, why don't you kind of take the ball with that one?
Sure. So if you're working for a subcontractor and the general contractor hires, then obviously you would not be able to sue your own employer. So you wouldn't be able to sue the subcontractor.
Wait, why can't you sue your own employer? If I'm working, let's say someone, the subcontractor is a roofer, and he says, okay, go on the roof and put the tiles, and that's your job. I go up there and I fall through, whatever, however people get hurt, right? Why can't I sue my employer for setting me up there?
Go ahead, Amanda.
So that's what we have workers' compensation for.
Okay.
And under the law, you're not entitled to sue your own employer.
So a decision was made many years ago to have what we call workers' compensation.
Sure.
And the idea was whether or not you were negligent or not, whether your employer or co-employees were negligent or not, you would be able to still recover lost wages and also medical benefits.
From whom?
From your own employer.
Okay.
So there was a trade-off. The trade-off was you're not going to be able to sue your own employer. You're not going to be able to sue your co-employees for the negligence. But what we're going to let you do is, even if you are negligent, you'll still be able to recover monetary compensation for being out of work, for some lost wages, and also for medical expenses.
So that's the extent of the damages that the employer will have to, and they generally have insurance for that.
Yeah, there's workers' compensation insurance, so they have it.
Sure.
So now you gave up. What did you give up in that exchange when it was really done?
You gave
it
up
was
the right to a larger reward for your pain.
right for your pain and suffering, and but you didn't give up the right to bring that claim against maybe a third party, somebody that's not your employer.
Okay, so even though you're going to collect workers' comp benefits, right, from your employer, it doesn't stop you from suing either the homeowner or the general contractor.
Correct. Those would be the two people generally who you would sue in that circumstance.
Okay, so you can receive the benefits of compensation and medical relief from the workers' comp policy, and at the same time, you can sue for pain and suffering and other issues
If there's a third party.
if there's a third party.
So sometimes what happens is, let's give the scenario that you just gave.
Right.
You go onto the site, and your employer is the contractor. There is no other contractors. Your employer is the only contractor.
Right.
And your employer tells you, all right, go up on the roof there and do something, and you get hurt. Okay? Even if your employer is negligent there, let's say your employer went ahead and didn't give you the proper safety device. In that case, you still couldn't sue your employer. Now, the question becomes, in that scenario, is would there be anybody else you can potentially bring a claim against? And the answer is maybe. And it's really above probably your ability to assess that, because you don't know and don't understand what the law says. You do not understand what the definitions are in terms of...
Are there laws that the contractors have to have insurance to cover their employees' accidents?
Yes, yes. Actually,
they have to have workers' comp insurance.
yes. An employer... Now, there are some exceptions to it. If you're self-employed, okay, and you literally don't have any employees.
Right.
You're it, okay? But in general,
Right.
okay, the answer to that question is yes, you should have workers' comp insurance.
By law, they have to?
Yes. And if
have
you
to.
don't,
Yeah.
very stiff penalties. So, we have people that have come to us in the past that, for whatever reasons, didn't have it at all or failed to cover a particular employee. And now they come to us, and now what happens is compensation, if they should have had it, will pay comp benefits to that person, potentially. But there's tremendous fines now against the employer who did not otherwise have it.
Fines
Fines,
from whom? The state?
yes.
Okay. But it doesn't help me, because if I get hurt on the job, I can't sue my employer
Well, you can't sue your employer.
if they have insurance.
Right.
But if they don't, I can?
No,
Oh.
you still can't, even if they don't have insurance. Now, there are exceptions to the exceptions.
So if they get fined, do I get any of that money?
Well, what'll happen
being
is
fined?
yes. What'll happen is sometimes. Well, let me put it this way. What'll happen is if you should have had them insured and you didn't,
Right.
there's provisions under the workers' compensation law that that individual will get compensated. There's a fund, okay. But now what happens is you get the wrath of the system, because you failed to have the insurance in place,
Right.
and the system now had to pick that up for you. Okay.
Gotcha. Okay.
It's not a place where you want to be, David. And I would tell any employer, don't put yourself in that spot. Just don't. And I've had many cases where I've had to help people,
Right.
where they've either made mistakes, didn't have it in place, or they kind of thought, well, I'll just do this one job. I have employees, but I'll just do this one job, and I won't have workers' comp. Don't do it. And even if you in a situation where you're going to be really careful, where you may think and say, you know what, these are really subcontractors, and you want to call them subcontractors.
Right.
But it turns out that they're really not subcontractors, because maybe, let's say, you're controlling their time. They only work for you, and you're controlling their efforts. Under the law may say, you know what, you really were their employer.
But let's say I get hurt on a job, and we've discussed this with auto insurance policies. They have underinsured. I mean, the workers' comp doesn't pay for perpetuity. I mean, there's got to be a limit to how much they're going to pay.
So they'll pay for 10 years.
They will.
Yeah, it used to be longer, but I know we had Bill Turley on. I think he said it was 10 years. Amanda.
Yeah, and he also explained, you usually only get a percentage because they put you at a percentage of what you are
Yeah,
disabled.
but if you can't work anymore, and your job was to do something physical with your hands, if you're a blue collar worker and you can't work, and now you're only getting paid a percentage of your salary, how are you going to make up the difference?
Well, that's a good question.
That's why you need to be able to sue somebody.
That's why you hope in those scenarios there's a third party.
And that's why you hire a Ken Auerbach.
That's why you hire us. You
Yes.
hire us to assess it.
Right.
And because our job is to see, is there a third party?
Right.
Can we get you fully compensated?
Right.
Because workers' compensation oftentimes is not going to be paying you full salary.
No.
If you're a person making, $100,000 a year, $90,000 a year, compensation is not going to pay you anything close to that.
Right.
Okay, so
It'll pay for your medical bills. Thank you very much. It'll pay a portion of your salary, but how are you going to support your family?
right, and then you can look into Social Security disability too, but
That's not gonna cut
The
it.
problem is it's not going to make it. So that's where
Right.
you got to come to us, hopefully, and let us assess it and
Right.
see, is there a third party? Can we help you? So
Right.
we'll see you on the other side. Really so glad to be here with you folks. Well, hi, welcome back to our program. If you're just joining us, this is personal injury attorney Ken Auerbach here with my great associate and co-host, Amanda Spinner. You're on our program from no fault of your own, and we are exploring some of the most important issues in personal injuries caused by accidents. And if you or someone you care about has been injured as a direct result of someone else's negligence, give us a call at 631-654-4900 or get us on the web at myinjuryli.com. That's call us at 631-654-4900 or get us on the web at myinjuryli.com. Privileged to fight to get you justice. We have, our new listeners out there today, right? We had Arthur and Dean and Patrina, and we have many listeners out there that are learning from our program, which is a great thing, right?
Yes. Also, shout out to our little technical guru, Dana. She also is sitting here recording our podcast, but she's learning a lot while she sits here, and she really enjoys it.
Well, we love having Dana here. Dana, you just get Dana Totoro. Remember that name, folks, because Dana's also an actress, actually.
Yes.
And Dana really will be famous someday. Okay, she's famous to us now.
I was
but
just going to say that.
she will
I
be-
heard she's a stand-up comedian.
she also,
she
is a
also
stand-up
does.
comedian.
Comedian.
Yes.
Dana,
Dana-
is it comedian? Comedian.
Dana does everything, actually. Dana went to school in the Smithtown School District, I believe, if I'm correct. And so if you're out there, folks, and you know Dana then, you can say like we did. We knew her when. So, but she really has been doing some great shows. She's doing a show now out in Vanderbilt. I think it's at the museum, I believe. And
In May, she'll be
May?
appearing in that. Yes.
okay, and that's supposed to be a great play. What's the name of that play?
The Complete Works of Shakespeare Abridged.
The Complete Works of Shakespeare Abridged. So, if you want to see a great show, go out there, okay? And if you
Sounds
say
like
hi,
a very, very long play.
Abridged.
Even abridged.
It should be 90 minutes.
it should be
not
90
bad.
minutes. So if you say hi to Dana out there and you give her your program, you'll get an autograph too. So and save that autograph.
Maybe
I'm
she'll
telling you.
autograph your From No Fault of Your Own t-shirt.
That could be too.
Oh.
So, folks, really, we'd love to help you. If you need us, please give us a call at 631-654-4900. Get us on the web at myinjuryli.com. All of our consultations on personal injury cases are always free. If you do retain us, and you don't pay us anything unless we make a recovery. It's all on a contingency, and we'll add expenses. You don't pay us those back either unless we make a recovery. Listen to our program every Monday, also from 4 to 5 p.m. as we explore these issues. And our consultations will come to you. You could come to us. We'll come to you in a medical facility. We try to make it as easy as possible. We'll come to you after work. And that's right, after work we say that because just because you are able to work does not mean you're not seriously injured. Oftentimes, people have to go to work. They have no choices, and they do the best that they can. And a lot of people now are working from home, so you can be seriously injured. I just signed up a case with a client, and she was home. She was injured, and she's really in a lot of pain, but she works from home. So she's able to go ahead and do that. But clearly, it's not as if she's not in pain. It's not as if she probably hasn't suffered a significant or serious injury. Most likely she has. So let's get back to the program, David,
All right.
and some of your great questions.
Okay, so what is the look back for an injury that is sustained on the job in construction? I mean, some people just need to work. They don't. I got to work. I know I'm not going to make enough money with disability, the workers' comp benefits that I'm getting, and I need to work. I am in pain. I have a soft tissue injury. My back hurts, all that stuff, but they got to go to work. Is it 3 years? Is it 5 years?
So
how far can they go back?
When you say a look back, could you give us a better thought when you're talking about that? So are you talking about...
Somebody gets injured and they wait a year to contact you because they can't afford not to work.
Okay. So the bottom line is this. If they're injured on the job, if you are injured on the job, you should report it right away to your employer.
Right.
Make sure that you do that. So if you have an employer, you need to do that. You need to report it. You need to file with workers' comp. Okay, very important.
But sometimes the nature of an injury can be aggravated further by continuing working. So you can hurt yourself and not realize even how bad the injury is because you've continued to work. It's not that bad. I'll get through it. You go back to work that week and keep working, and just aggravate the injury to the point where you can no longer work.
So there's a couple of
And
questions.
then your boss says, "Hey, you were fine," for a week or so after you complained about your injury, your fall.
Amanda, there's a couple of questions within that. Do you want to kind of hit a couple of them?
I gotta dissect that. Do you want to go first? And
Sure. So, David, let's talk about, you said, can you go back to work? Do people go back to work when they're hurt? It happens all the time.
Yeah.
And you're not wrong. People do what they have to do. I tell my clients, listen, I don't tell anybody stay out of work.
Right.
If you can't work,
Yeah.
of course, stay home, get better.
Right.
But if you have to go to work, like many people do, you go to work and you see if you can cut it.
But does that reduce the severity of the injury? And at the same time, will that reduce the monetary compensation that one might receive?
It might. It depends on the scenario.
Yeah.
I mean, I have people that have tried to go back to work. They didn't realize how hurt they were.
Right.
The insurance company now for the third party is defending the case, saying, well, your person went back and worked 3 days, the 3 days after. Okay?
Sure.
Well, they didn't realize that they had such a bad spinal injury that was going to require them to have surgery.
Right.
Okay, and they wound up having surgery. So, of course, we fight, and we oftentimes fighting with the insurance company later when we're making that recovery, let's say, against the third party. Let's say there was a third party that I could sue, and they're like, well, your client couldn't have been that hurt. They went to back to work for 3 days.
Right.
Listen, I've argued to a jury, and this is what I've done to juries, many juries. I stand up in front of juries and I say, look, my client doesn't apologize for going back to work. That's what good, decent people do.
Right.
Good, decent people go back to work. Good, decent people are not trying to make something worth more from a lawsuit standpoint. The reality is that there are different scenarios. I remember one case where I had a brain injury case. Clearly, the woman had a severe brain injury. She went back to work 8 days after the accident, but for the next 3 or 4 years, she kept on having dizziness and imbalance. In fact, she would lie down at work on the floor, and she worked a sedentary job. So she went back to work because her position was, I'm the sole wage earner,
Right.
and I can't afford not to work.
But she was lying on the floor while doing it in pain.
But I'm doing the best that I can do. But they defended the case. They fought us on that case. And they said, well, how hurt could she work? She went back. So I said to the jury and argued and said, look, use your common sense. What does your common sense tell you? Okay. Should a person who can try to do this, for a person that can pick up the pieces and at least maybe they don't have 100% of themselves, but they have 75%. Should that person now not come to work? Should they be forced not to work just so that they can have a viable case? Or should they now be able to come back to work and you now hear this case and you get to award what you think is fair and reasonable based upon what they have left?
Right.
Okay. And so we run into that. Okay. We run into that and they defend those cases. And I actually love people. I love people who do the best they can about trying to get back to work. Some people can't.
Right.
But the people that go back to work, I've said to juries, what would they have said to you if this person didn't go back to this sedentary job? They'd call that person a phony and a malingerer. But this person went back. This person isn't asking for a handout. They're asking for what's fair and just compensation.
Right.
And now they can't do all these other things that they could do.
Well, that's what I was going to say. Let's say you get injured on the job and you can go back to work, but you can't play golf anymore. You can't go skiing anymore. You can't get on a canoe anymore or do the things. You can't pick up your kids. There are lifestyle changes that you need to make.
Yeah, and Amanda,
You can still earn money, but you can't do anything else.
Amanda, we've done that on cases.
Yeah, and you have to separate out the economic portion for a job versus, not being able to perform your activities of daily living,
Right.
which diminish your life. Yeah. And, that's part of your conscious pain and suffering.
Right. It's called, as Amanda said, it's diminishment of life. It's called loss of enjoyment of life. So within pain and suffering, it's pain, actual pain, conscious, but it's also losses of life.
Right. So if somebody gets injured on the job, and even though you can go back to work, but there are a lot of things that you can't do, don't not call your office because, he's not going to take the case because I can still go back to work. You may not be able to go skiing or snowboarding with your family anymore.
Yeah, and you're right. And they get injured on the job. What we want you to do is give us a call.
Right.
Okay. We don't downplay losses.
Yeah.
It's I guess easier to think about someone else's losses. Maybe not as big a deal.
Right.
But think about yourself, folks. And if you sit on a jury, think about yourself. How would that affect you?
Right.
How would that affect you?
Yeah, and wages are only one portion of, like we said, one portion of what you can recover.
All right. Well, listen, we ran out of time, David. Really appreciate you on the show.
My pleasure.
Get us at 631-654-4900. It's 631-654-4900. Everyone have a safe week. Enjoy the heat.